Welcome into another edition of Legal Access. Appreciate you joining us today. We're going to be talking about workers' compensation. If you've been hurt on the job or know somebody who has, make sure and get your questions answered today. Phone number is 843-848-8080. Give us a call, and our panel today will answer your questions on workers' compensation. On the panel to do so from the McGuire Law Firm, first of all, is Ian McGuire.
See you, Dave.
And also from the O'Neill Law Firm is both Josh Koshin and Rick O'Neill.
Hey, thanks for having us again.
Absolutely.
It's great to have both Josh and Rick especially comes on our show a lot and does such a great job. And Josh, I know your practice obviously handles workers' comp, which is what we're talking about today, but you also do criminal defense work and you do personal injury and anything else I'm missing that you guys?
No, that's the bread and butter. I mean, it's basically personal injury with a focus on car wreck cases and workers' compensation, and then we do some criminal defense too, traffic tickets, things like that. And
every once in a while I remind people that Rick, before he had this long distinguished career as an attorney, he was in law enforcement. So the fact that he handles DUI and other criminal matters makes a lot of sense, and I know your firm does a great job with both the civil and criminal realm. So today, obviously, our topic, Dave, is workers' comp, and if you have any questions, give us a call at 843-848-8080. It's 843-848-8080, and really, if you have any questions that are outside workers' comp and that Rick or Josh can answer, whether it's personal injury or criminal matters, don't hesitate to give us a call at 843-848-8080.
All right, let's go ahead and start at the beginning as far as workers' compensation is concerned. Let's say you've been hurt on the job, even if it's an injury that doesn't really think that it requires any missed work. What is your first thing that you need to do as an employee?
Well, you always want to report the injury immediately to your employer. If you don't do that, you have certain deadlines that you can miss. You have in South Carolina 90 days. I know in other states like North Carolina it could be as short as 30 days. And you also have 2 years to actually file a claim and pursue that through the South Carolina Workers' Compensation Commission. So you don't want to wait until the day after or multiple weeks later to report it. You want to get that documentation early on, and then your employer can decide whether to send you to the hospital if it's an emergency, maybe an urgent care or something like that, and they will usually write up a report of injury as well.
Yep. And preferably in writing. Emails are better than text messages, and a letter is better than an email.
Yeah, but you're right. You don't want to he said, she said, or he said, whatever down the line as far as was there notice. A simple email or text is certainly trumps just a conversation that you can't really prove. So it just, even if you have the conversation, just follow it up with an email or a text and confirming what you talked about.
If it is an injury that looks like you're going to be missing work, I mean, what happens next? Does the Workers' Compensation Commission assign you somebody that's going to be your caseworker from there, or what goes on next?
Well, the Workers' Comp Commission usually doesn't get involved in a day-to-day claim unless either side requests a hearing before a commissioner. So generally, initially, it's going to be between you, your attorney, and the workers' comp adjuster. Sometimes the workers' comp insurance will hire an attorney right from the beginning, but generally, a defense attorney doesn't get involved until a hearing is requested.
We have a lot of claims where our clients call us and they handle the insurance claim on their own before they ever get an attorney involved. And usually an attorney is not always necessary in the beginning because they're getting the treatment, they're getting paid for being out of work, all the benefits that they are entitled to. And then something comes up where they need to get some important imaging, an MRI, a surgery or something like that. And then they get a denial from the insurance company, and then they got to figure out how to proceed best from there. And so that's when an attorney often gets involved. Sometimes we get involved, the day after. Sometimes we get involved months and months down the line.
Right.
Yeah, I always urge people, if you're going to end up most of the time needing an attorney if it's a serious injury, the employer and the insurance company has their attorneys. You might as well hire someone that's on a contingency. You might as well hire the attorney early. make sure that your comp rate is correct, make sure you're getting the treatment you're supposed to get. Sometimes it's harder as attorneys when we come in later in the game and there's already things that have already been handled a certain way or not handled, and it's hard to go and fix it then. So the earlier, if you're going to at least sit down and talk to an attorney early on, Josh mentioned there are times where a claim can be handled without an attorney, but you should at least get what essentially is free legal advice early on.
Right, I know your office provides free consultations. Our office does as well. So it's not something where you're having to step foot in the door with an attorney. Other attorneys in our practice area, most of them that I know, do free consultations as well. And when you say contingency, it just means, hey, if we recover some money for you, we would take the standard percentage of that, which in South Carolina, most attorneys do a third.
And it has to be
whatever the
approved
recovery
by
is.
the Workers' Comp Commission, right?
Correct. So why wouldn't you at least set up a meeting, get a phone call with an attorney, get that free legal advice? And most of the time you can just go with the attorney early on, but I mean, at least getting the free legal advice is usually helpful to point you in the right direction.
Agree.
And speaking of free information as far as workers' compensation is concerned, the McGuire Law Firm has put out a book. It's called Mistakes That Can Destroy Your Workers' Compensation Case. It is available for free at the McGuire Law Firm office, which is at 1600 North Oak Street in Myrtle Beach, or you can go online to McGuireLawFirm.com and download it for free on the website as well. So pick that up. But again, as Josh said, call somebody and get a free consultation as far as your workers' comp case is concerned. As far as other things are concerned, now, are there injuries that you might sustain that are harder to find compensable, like hernias, etc.?
Hernias, repetitive motion where you're scanning, let's say at a cash register, occupational exposure cases, those all require a little bit more proof, sometimes a lot more proof in medical evidence. So those type of cases, you really need to get that free consultation with an attorney or retain an attorney early on your case, because they're harder to prove and recover.
Yeah, those repetitive, cases. Back in 2007, when there was some changes, that was one of the things. They made it a little more difficult. You basically just need a doctor that will causally connect the workplace injury,
Right.
which it comes from the repetition of your job, the whatever you're doing, to the symptoms that you're having. So it's just a little more complex than a normal case where you just have to say it happened at work.
Right.
Unhurt.
Tell you what, we're going to run to a break here real quick. When we get back, we'd love to answer any questions you have about workers' compensation, either as an employee or an employer, whichever the case may be, or if you've been hurt on the job or know somebody who has, or if you just have general questions or something specific. Phone number's on your screen. Give us a call. We'll answer those questions when we get back in just about 90 seconds here on Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access, brought to you by the McGuire Law Firm. Workers' compensation, that is our topic here today. If you have any questions along those lines, like I said, as an employer, as an employee, or if somebody in your life, yourself or somebody else, has been hurt on the job, today is the day to get those questions answered. So call us. Phone number's on your screen. We would love to talk to you here today on Legal Access. Okay, what's the difference between if you've been hurt on the job, if it's a part-time job, or if you're an independent contractor? But if it's a part-time job and you get injured and it's going to affect you being able to work at your full-time job, what's the process like that as far as comp is concerned?
Well, you can get compensation for not only the job that you were injured on, but also any secondary employment you have. So if you work 2 part-time jobs, or you work a full-time job and then a part-time on the side, the Workers' Compensation Commission typically factors in your total wages from both of those. Now, every year, and it's gone up over recent years, but you're entitled to a certain compensation rate. So if you make gross wages $900 a week between the two jobs, you're only going to get paid $600, so 2/3 of whatever your average weekly wage is. And
But it's not taxed.
yeah, and I was going to say it's typically that's not a taxable income or anything, so you just get the flat 600, and they won't take any of your taxes out of it or anything like that. So.
In workers' comp, these calculations really are all over the workers' comp system, whether it's your average weekly wage and your disability checks or your permanent impairment for different body parts. Every body part is assigned a certain numerical value of weeks. And so when you go to get released from your doctor, you take the different body parts, you factor in your compensation rate, and you put it in a mathematical calculation, and it's not like a jury trial where you get money for pain, suffering, punitive damages. It's all tied to body parts and your wages at that time when you got hurt.
Yeah, and Rick, you know as well as I do, if you hurt your finger at work, that's not going to be worth as much as if you hurt your back or your shoulder or your neck or something like that. So they really classify the compensation, and it goes up more depending on how crucial that body part is to a worker's ability to make a living.
And Josh, you mentioned that if you work two different jobs, you can get your comp rate will be considered on both jobs, and which is something in South Carolina. It's not. If you go to other states, it's not done that way. It's just the job you're hurt on, and so. There's a lot of things people complain about in South Carolina with the workers' comp system, but all in all, it's a system that is pretty well balanced as far as looking out for both the employer and an injured person. When you have multiple jobs, the job that you're not hurt at is not getting penalized in any way.
Right.
Just so we're clear, even though you could add that as part of your aggregate income, it's not affecting that job in any way. So if you don't have an attorney, don't worry about that. Just get proof of how much you were making at the different jobs that you're working at, and they can be combined for that purpose.
Right, so if you're working a landscaping job and your average weekly wage is $500 versus your full-time job where you're working or 30 or 40 hours or so, and you're working at the Myrtle Beach Airport, and you're making $1,000 a week for that, you would add the 500 and the 1,000 to make a 1,500 average weekly wage, and then if you're ordered out of work by the doctor, you should be making 2/3 of that, which would be $1,000 per week. But if you're injured on the landscaping job, you would go through the landscaper's workers' compensation insurance. You wouldn't be going through the insurance for the airport.
Exactly. Yep.
Now, as an employer, who's required to have workers' compensation insurance?
Well, before we say required, I will say that just as a protection, I would say wholeheartedly everybody should get workers' comp insurance if you have employees. But Rick, do you want to talk a little about who has to have it?
You're required if you have 4 or more employees. There's some exemptions, such as farms, some farm workers. You don't have to have workers' compensation. But even as a solo employer, you can get workers' compensation that covers yourself. We've had a lot of cases over the years where people have called, they fell off a roof and wanting to get a claim going, and they didn't have workers' comp. They said, I wasn't required to, and now they're looking for the compensation and some serious injuries, and they have no way to pay for them or get a disability check while they're awaiting surgery or so forth.
Yeah, so 2 points to that. One, if you're supposed to have, and if you have 4 or more employees and you should have workers' comp insurance and you don't, what'll happen is the fund will step in and cover it, but then they're going to go back for whatever the results are and try to recover that, and they will have a lien where they'll recover that money directly from you. So you really, if you're supposed to have insurance, make sure you have it, because it really can get costly between medicals, future medicals, and of course permanent injury. So even if you're in a situation though where you don't have to have, and Rick mentioned if you have 1 or 2 employees or even just yourself, if you have 1 employee and you didn't have to have insurance, but somebody's hurt on the job and there's no workers' comp insurance, they could potentially potentially sue you outside of the umbrella of workers' comp. And Rick mentioned that, in those cases, there is loss of enjoyment of life and pain and suffering, things that are not a part of a workers' comp claim. So you might put yourself in a really difficult situation by not having workers' comp insurance. So just urge everybody to really look into having it rather than not.
A lot of construction going on in our area. If you are working with a subcontracting group and you get hurt on the job, but the subcontracting group you have has less than 4 employees and you don't have workers' comp insurance, can you get it through the contractor?
Yeah.
Yeah, so let's just say it's the builder or it's the construction company and you're doing vinyl siding or something like that and you get hurt. South Carolina has a statutory employer law where if that is such an integral part of the business that you can get covered and go upstream from the subcontractor to the upstream builder or construction company and get coverage that way. And that happens all the time here, obviously at the beach. I've seen the numbers out there. We're growing like crazy, and every time you travel half a mile down the road, there's a new development going up. So I think that the fact that South Carolina has that law is super important to cover these people when there's no insurance. And usually when you're dealing with a construction type work accident, it's pretty major injuries, broken bones, torn ligaments, things like that.
Yeah.
Tell you what, we're going to run to another break here real quick, but we'll be back in just a couple of minutes, and we still have about 10 minutes left in the show, so we got plenty of time. If you have any questions about workers' compensation, give us a call. We'd love to get you on the air. Phone number's on your screen. We'll talk to you in just a second. More about workers' compensation right here on Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access, brought to you by the McGuire Law Firm. Workers' compensation, that's our topic here today. If you have any questions, we've got a little less than 10 minutes to go, but give us a call and we'll get you on the air to get those questions answered. On the panel to answer those questions for you today from the McGuire Law Firm is Ian McGuire. Also from the O'Neill Law Firm is Josh Koshin and Rick O'Neill. So we're well equipped to answer any workers' compensation questions that you might have of us today. Now, if you're instructed by your employer or manager to go to a certain doctor to get yourself looked at after you've had an accident at work, but they don't find anything, or you think that they're not giving you the right diagnosis, do you have the right at that point in time to go and get a second opinion?
Yeah, absolutely. We have this happen all the time. Just kind of a precursor to that question, when you're dealing with a workers' compensation insurance, the employer is going to pay for your medical treatment, but the employer gets to pick your doctors. So typically, if you wanted to get paid and you want to be evaluated and treated, they're going to send you to their doctors that are in their network. Sometimes you don't necessarily agree with the opinion, or you're not getting the treatment that you want. So clients will call us up often and let us know that, and we can either request a second opinion through the insurance company and see if they'll approve it, which most of the times, more often than not, they will. If not, we may be able to send them to a physician of our choosing to get evaluated for what kind of treatment they want, and then fight it that way.
If that doctor says, okay, you're cleared to go back, and they tell your employer that he's fine to go back to work, but you don't feel that you are, what do you do at that point?
Well, you can always get a third opinion, or you could try to go back to the original doctor and complain about the symptoms that you're having. Because oftentimes we have clients that will go to the doctor, and on that day they're feeling really good. They're 1 out of 10 in pain, 0 out of 10 out in pain. But then they go back to work, and they have issues because they're doing those movements that they have to. They're doing heavy lifting. So you can always go back through that way. You could always file a claim to the Workers' Compensation Commission to ask for more treatment. We have this happen all the time where people get released and they're not good to go, and they're feeling fine when they've been out of work and they're getting their benefits, but they go back to work and they do something and it's just back to square one.
But I mean, if you're ordered back to work by the treating doctor and on a Friday and you're supposed to show up on Monday, you really, if you don't have an attorney, then that's when you need to immediately get legal advice, because you run the risk of losing your job if you don't show up on Monday. So I mean, you're really not the the judge on whether you should go back to work or not. It's, the law and the workers' comp system decides that, but you got to be real careful about on your own deciding, well, I'm just not going to go back to work because I can't do my job duties.
Yeah, and a lot of times what we see is they'll go back to work and they have some kind of restrictions for short-term restrictions and they're not being followed. The best thing to do is not to leave the job, and the best thing to do is let your attorney know, and then you'll get it straightened out, because they have to act within the restrictions at work, and
Right.
if they don't have a job where it's within the restrictions before the client gets to MMI or the patient gets to MMI, then they should be paying them their weekly wages,
Right.
temporary weekly wages until they're able to return to.
Okay, let's say that you've been cleared. They said you can go back to work, but you get back to work and you're not able to do all the stuff that you were doing before the accident. And you don't have light duty work or anything else that they can give you. And they say, well, Dave, I'm sorry you can't do the job anymore. We're going to have to let you go. Is that legal? Can they do that?
Sure. It's an at-will state, so unless there's a contractual issue, that happens a lot where people will be hurt. They'll get hurt on the job, and then after 6 months, they'll get a letter saying, you've been out of work 6 months. Unfortunately, our policy is at that point, and they can do that. Is that going to help the injured worker with their workers' comp claim? Probably, because now they've lost their job as a result, admittedly, of the injury that occurred at work. But it happens, and it's not illegal to do that in most cases, Rick, right?
Right.
Josh? Yeah.
It's illegal for the employer to fire somebody for filing a workers' compensation claim because they were injured on the job. Now, the law is not going to require the employer to employ someone and keep them on the payroll and doing the job if they're physically unable to do it. So you may be able to get some benefits through your workers' compensation claim for that. But
So it can't be retaliatory, is what you're saying, right?
Exactly. They can't retaliate because you filed an injury claim because you got hurt at work. But let's say you're working on a construction site and you have to lift a lot of weight doing that, obviously 50, 100 pounds, and you have a back injury and a 20-pound lifting restriction. If you go to work and they say, hey, look, we just don't have any light duty for you to do within those restrictions, you may be able to still collect money for being out of work when they can't offer you a suitable position within those restrictions.
And there's a built-in conflict, because what you have is you get put on light duty by your doctor, and you've been collecting the weekly disability checks that are being paid by the insurance company. The insurance company wants to stop that money flowing to you, so they're pushing you back to work. And then the employer doesn't have any light duty, and they really don't know what their rights are. They're like, well, I guess we can create one, and really, and they're getting pressure from the insurance company, put this guy on light duty. But as an employer, if you don't have any light duty positions available, you can tell the insurance company, say, listen, there is none. I'm not going to pay this guy to just sit in a chair and do nothing.
That's what I have workers' comp for, right?
Right.
Insurance for.
I paid my premiums for these type of situations, and so you should step in and provide the benefits for the premiums I paid.
And that's maybe as an employer where you need to get just a free consultation with a workers' compensation attorney to know what your rights are as a policyholder.
We've
Absolutely.
only got about 30 seconds left here. When does workers' compensation turn into like a permanent disability that you might get? At what point? I mean, can you figure that I'm never going to be going back to work ever again?
So usually when a doctor releases you at what we call MMI, or maximum medical improvement, they'll give you what we call an impairment rating, and based on that percentage, we can also factor in other things on top of your ability to work, and we can get a permanent disability rating.
Next week when we get here, we got wills, trust, and estates, so write that down. Make sure and ask your questions next week. I want to thank our panel here today, Ian McGuire, Josh Koshin, Rick O'Neill. I'm Dave Priest. We'll see you again next Thursday morning for another edition of Legal Access.
You may wish to consult a lawyer to obtain case-specific legal